Sunshine State. This is Tampa's TAN Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock, and we are live on the radio. My name is Matthew Noyes, and I'm one of the attorneys at the law firm of Perenich, Caulfield, Avril Noyes, a personal injury firm here in Tampa Bay. In fact, the oldest personal injury firm in Tampa Bay. We have been around for 70 years. This year, we are celebrating 70 years of helping people after their car accidents, work comp injuries, slip and falls, or other personal injury matters, as well as helping people fight for their Social Security disability benefits. And we are here, and we are proud to serve you with FLALAW on the radio. This is a live call-in show, so if you have questions, this is the time to call in at 727-441-3000. And if you don't want to call in and hear your voice on the radio, but you still have a question, you can come to our Facebook page. We are live on Facebook right now. You can type in your question right there, and we'll be happy to tackle those questions as well. The Facebook page is Perenich, Caulfield, Avril Noyes Injury Lawyers. And you can just type your questions right there. You can, in fact, see us here in the studio. And one other way to get in touch with us is by our YouTube channel. Jump on our YouTube at Perenich, Caulfield, Avril Noyes. Get on the YouTube channel, and Ed on the other side of the glass will let me know that you typed in a question, and we'll be able to tackle that question for you as well. But I'm not here alone. I have my friend and my colleague, Patrick Gaffney, here. Patrick, thank you again for coming on to the show.
It's my privilege, Matt. Thanks for having me.
Patrick, could you give a little bit of your background to our listeners? I know you've been on before.
Yeah, I've been on a couple times. I basically grew up in Clearwater, Dunedin. I went to Dunedin High School. And so this is kind of like home. I come from a somewhat large family. I'm the fifth of 6 kids.
That's pretty large. It's about half the size of mine, right, but that's all right.
You come from a big family too. And so when I came out of law school, I started as a prosecutor, and that was like over 40 years ago, did 3 years there. And I've been in private practice since that time. Not too far from where your office is.
That's right. You're right on Sunset Point, right around the corner from us.
I see it's my vocation to try to help people, and that's what I'm doing now.
Yeah. And what type of areas do you specialize in?
Right. So 1995, I became certified as an expert in family law. So since that time, that's what I've been doing. In fact, I'm up for recertification. I have to send in my package for recertification this month. So it's been primarily family law, which is divorce, paternity-related agreements. I also, though, engage in some estate planning. I do wills, trust, probate administration, that sort of thing.
Okay. All right. So listeners, if you have any questions regarding those areas, family law, divorce, child's custody, alimony, or even estate planning, Patrick is here. He's given up an hour of his time to be here to answer your questions. So again, call us if you wish at 727-441-3000, or jump on Facebook Live, Perenich, Caulfield, Avril Noyes Injury Lawyers. Jump in while the show is still early. Oftentimes, near the end of the show, we get a lot of callers or a lot of messages, and we just don't have time to get to them. So this is the time to do it if you have a question. But Patrick, what I really want to talk about a little bit, well, first of all, before I even talk about family law, you mentioned that you're board certified.
Yeah.
That's something that not all family law attorneys are. Is that correct?
Yeah, something like 2% of all lawyers are board certified. So it's
a big deal.
Well, it's depending on who you talk to.
Yeah,
it is.
I
mean, as I've said, I don't think it's required to be board certified for most lawyers. There's some very great lawyers that aren't board certified. But what you have to do to achieve that is you have to take a test and you have to be recommended and you have to have so much experience in continuing legal education. So it sort of presents to the public someone who may know what they're talking about.
It shows your dedication to that area of law.
I would agree with that.
Yeah. I mean, that's why I think it's hard for an attorney to do personal injury, estate planning, criminal law, real estate. You know, you're doing so many things, you're wearing so many hats, you don't get to really specialize in one area.
You can be a jack of all trades and a master of none.
That's exactly true.
The idea is to be a master at something. And of course, there's still areas of family law that I have to research and look into. It's a fascinating field. And I think the most fascinating and alluring part, the part that interests me, is the people, is just having the privilege to meet people and see their situation. And something about the human condition, Matthew, where people get themselves into trouble, into problems, and they have to seek help to get themselves out of it.
Right.
And that, as you know, certainly in your area, that's true as well. But that's the privilege of the practice of law, and it's been my life's passion since I started.
What directed you to family law?
Well, as I came out of the state attorney's office, I did criminal defense. And then it sort of gravitated, part of it was I chose it, part of it chose me. I got introduced to it. I could see that I was effective at it. Like I said, I like to connect to people. I like to understand their problems and help them through their problems. The other aspect, one of the many aspects of family law, is this whole idea of what people do when they're challenged with something they didn't expect, like a divorce, and how they act. And you probably see the same thing in accidents. People
exactly true.
That have no, they drive to work one day and they get into an accident, their life has changed forever.
Right.
And they now have to cope with a reality that wasn't on their radar screen.
Exactly true. A new normal.
Yeah. And it's always fascinating because, the human condition is such, if we don't have a way of dealing with those problems in a healthy way, there can be unhealthy ways to handle it, addiction, for example, and you don't want to do that, obviously. And so, I think it's just the people, the problems people get themselves into, the resolution, the joy you see with people who eventually come through a difficult time. And again, that's something you probably see with accidents. You see someone who's in a very compromised situation and they're sort of down on their luck, down in the dumps, but then you can, over time, there's my mother used to have the saying that everything passes and this will pass too.
Right.
So, most things will pass. There is going to be an element of suffering and difficulty in all aspects of life.
Right.
And, to have an anticipation, which a lot of us do, that that's not going to happen is not realistic. It's just to me, it's more about being grateful that whatever bad has happened to you, it could be worse.
Right. And I see it as, these people, our clients, are they're like dropped into a maze and they're like, okay, how do I get out of this? And I see our position as the attorney, whether it's an auto accident or even Social Security disability, is, we got the minor cap on and we've been through this maze already. And so we can guide them. We can help lead them through it. And I think really that's what a lot of clients want, is just someone to walk with them and help them through the process. They don't want us to do the whole process, but they need us to guide them through it and to help them to understand what is happening and what will happen into the future because of the maze that they were put in. I think that's the same thing with family law as well.
Well, I think one of the challenges that you encounter as an attorney is to set appropriate expectations for a client. What they may know about their situation, they may have gotten from a TV show, which, is a drama. It's got very little to do with the real life. And what I have to do many times is take them through the whole process. This is how it starts. This is what you're going to have to do. This is what you should expect is going to happen in terms of what your responsibilities are to me, getting me information. And it's going to take this much time to process it. And people, don't really realize that it takes time to get through the court system.
Right.
And I think this applies to all legal matters, injury matters, family law matters, and others, which is, people are generally well advised to try to find a solution,
Right.
rather than take the system to its logical extent and go through the judicial process, having a judge decide. Because most times, in my experience anyway, most people, with the help of a guiding hand of someone who knows what they're doing, or maybe even more than one guiding hand. We many times in family law deal with other experts such as forensic accountants and mental health professionals. You're much better off, normally speaking, with trying to resolve that case, that situation, without judicial or a judge telling you what to do. Because when you think about it, our system's set up and it's the greatest system in the world. But what you're essentially doing when you call upon a judge to try your case is you're going to take an agent or a representative of the government. In this case, in the law I do, it's the state government, a state circuit court judge, to get into the most personal and intimate parts of your life and tell you how your future is going to be.
Right.
Think about that. I mean, that's pretty extreme, but that's really what we're doing, because when people are in conflict and they can't find their way through that conflict without help, they're left in a, like you said, a maze or a place you can't get out of. And they have their last resort is, judge, tell me what to do. It's really a sad place to be. I try to get people to a place where we can settle the case if it's possible to settle. And I think that's the best outcome, because another thing about what I do is we charge by the hour. Whereas I believe most of your stuff is probably contingency. But when you're charging by the hour, you realize the more I have to do, the more, especially when it comes to trial work, the more expensive it becomes.
Right.
So,
and similar in our personal injury matters as well, although it's contingency. Once you go into litigation, the costs go up. The costs, and in fact, the attorney's fees go up from 33 1/3 to 40%.
Right.
So I think it was Abraham Lincoln who said, "Settle if you can settle. Fight when you need to fight." I probably added the "fight when you need to fight" part.
I'm familiar with that term of Abraham Lincoln. I think it's on my website, where he's speaking to law students. And he says, advise your clients to settle. And I'm paraphrasing also, because when you look at the cost and the time and what you got to go through, you're better off.
And
settling.
the emotional drive that you have to go through.
Yeah. So, but what we encounter sometimes, is we encounter people perhaps on the other side of a case who maybe have mental illness, or they have a grudge they want to pursue, or a mental illness, addiction, one of these things. And it can be difficult. And there are a certain number of cases that are going to have to go before the judge because of that. When I look back on the cases I've tried, I kind of say, well, I can point out where the problems were. And it's usually either a problem with one of the parties or with the other attorney. Usually not the judge, because the judge does, a good judge just calls balls and strikes, doesn't interject themselves into it. But I'll tell you something else, Matt, because I think about this a lot. When a divorce takes place, a breakup of a relationship takes place, there can be hard feelings. There can be anger. There can be a whole host of things that are not healthy for people. And unless a person has a way of processing that healthily, well, then that just turns to a dark place where they can be like a wounded animal.
Right.
And that's not good. So that's where someone's mental health can be addressed by a mental health professional. A little bit of wisdom from a divorce attorney doesn't hurt.
Right.
Having a faith tradition they follow, most of which deals with let's find a way to forgive people so that we can move forward. Because ultimately, if you don't forgive someone, you're carrying it on in your own way, and you want to be released from that.
Life is going to continue. It depends on how you want it to continue.
Yeah, it's easy said, as we can talk in a detached way, but in a meaningful way, it's difficult for people.
Sure.
It's difficult to forgive.
Right. No.
It's difficult to get over if someone has betrayed you. I mean, I deal with this issue of betrayal quite a lot, where someone has alleged, had an affair or done something where they're not trusted anymore.
Right.
See, marriages and relationships, any relationship, is built on trust. When you asked me to be on this show, I showed up and I trusted you would be here, and you showed up. That's an example. But
Right.
but when people are counting on each other, trusting each other that they're going to be part of this life together, and then they have a betrayal, it's one of the more difficult things that humans have to deal with.
No, that's for sure.
Yeah.
Listeners, you are listening to Patrick Gaffney. He is a family law attorney here in Clearwater in Tampa Bay. We are here to answer any questions that you have regarding family law matters. If you have questions regarding personal injury, workers' comp, or Social Security, you can call as well, and I'll be happy to tackle those. And if it's an area of law that neither one of us specialize in, you can still call. Well, you can play Stump the Lawyer. We're happy to try to tackle it. You can call us at 727-441-3000, or just jump on our Facebook page, live Facebook page at Perenich, Caulfield, Avril Noyes Injury Lawyers, and type in your question there. We'll be happy to tackle that as well. But Patrick, I wanted to really get into the nuts and bolts a little bit about family law, because I think some of our listeners may have an idea what family law is and may not fully appreciate what laws come into play. And so I'm going to focus really on divorce, but please feel free to stretch out as far as you want to go.
Sure.
But, when we think of family law, what does that all encompass?
Well, hundreds of years ago, we took our law from the country of England, common law.
Right.
And under common law schemes, as societies developed, they're formed over time the institution of marriage. And in the olden days in England, it wasn't easy at all. It was very difficult. As I recall, it required an act of parliament to actually get divorced.
Wow.
So we have this whole sort of ancient institution of marriage, which carries with it certain rights and responsibilities. Now, it's interesting to note, Matthew, that I'm seeing an increase in my practice of people who have children who are not married, who maybe have rejected the societal norms, the religious norms of family life. Now, people will tell us that the reason why we have such a great society in the United States is because we have this society based on family, where you have your whole economy is based on people that want to have a home and raise children.
Right.
And so the whole concept of family is tied up in our societal norms and in our ancient laws that have now been brought over to our current laws, which when someone enters into a marriage, their life has changed because they are seen in a different way. They are in a different legal status and different rules apply. Because of that, some folks will enter into what's known as a prenuptial agreement, where they essentially make up their own rules of what will apply to their marriage. In some cases, that can even occur after the marriage, and it's called a postnuptial agreement. So in the absence of those agreements, when you enter into the status of marriage, your life doesn't become your own anymore. It becomes what society, through the laws, have indicated what your responsibilities are. An example of that would be the concept of alimony, where in our laws, and it changed in July of 2023, if certain facts are presented, such as the certain length of marriage, and further, if there is a disparity or difference in the incomes of the husband and the wife, well, then the law would apply, and it would impose upon one of those marriage partners, perhaps, an obligation to support the other one.
Right.
Now, that is not something that goes along very well with most people, especially those who have a self-interest involved, because we're brought up in this capitalistic society where there's a lot of me, not so much what it should be, which is caring for the other person. And we have struggles with this because the law now, recognizing you are in a different status than being a single person, imposes this upon you. But even if you're not married, for example, and you have a child, again, if you have a child, your life is not your own anymore, because even though in the absence of a marriage relationship, the society through the laws in this case, a paternity case, will impose upon the parties certain obligations, certain privileges. Those of us who have children know that it's a privilege to have and raise children, but also certain obligations. I mean, you must care for those children, or the Department of Children and Families can come and take those kids away from you. That's a societal thing.
Right.
And you must support those children, or you can be, the Department of Revenue can come after you for child support.
Yeah, and I do want to talk about that child support as well. But it does look like we do have a caller on the line. Hi, Dee. Thank you for listening, and thank you for calling in on FLA Law on the radio. How can we help you?
Oh, thank you so much for taking my call.
Sure.
Yes, sir. I wanted to talk on air about intrinsic fraud on the court through disclosure, financial disclosure, when you're going through a divorce.
Okay.
And go ahead.
What question do you have about that?
Well, I went through a divorce, and my former spouse committed an intrinsic fraud on the financial affidavit.
Okay.
I was separated from him, and he had a paramour. And I don't care what he was doing with any other, whether it be a female or a man. We were separated. So during the course of him being separated, between he and I, he took on the role with this woman, and they got a house together. And in Florida, I was still married.
Okay. So I think the questions you have, Dee, for Patrick is, what happens if there is some misrepresentation on a financial affidavit during the divorce process? Is that a fair way to?
It's called equitable distribution of marital assets and liabilities. And he committed intrinsic fraud. He did not disclose that he and this woman bought a house together. I had the canceled checks that I was able to retrieve. I don't know how I did this. In fact, when I was before the judge during the proceedings and stuff, he said to me, wow, you should be a detective because, but here's the thing. I was going through the motions of like finding things out, but this took a little bit of time, a lot of paving the cement, so to speak.
Pounding the pavement, trying to find
pounding
the
pavement. Yeah. And here's the thing. I hired an attorney. I retained this attorney. Then no sooner when I had to come see him to meet with this attorney, he was a no-show because he was arrested. That happened here in Pinellas County, actually. I can't. I'm not going to disclose.
No, but Dee, what question do you have for Mr. Gaffney?
Well, here's the thing. I would like to go, and I would like to pursue this in the court of law because he did have a home with this woman, and that house was a part of my proceeds. So
let me ask you this, Dee, and Patrick can step in if he wishes. So that house that you're talking about that was co-owned with another woman, was that not part of the equitable distribution order by the judge?
Well, no, sir. That
it was excluded. He did not disclose that asset. All right.
That's right. He did not disclose that, sir. That's a fraud.
Okay.
That's intrinsic fraud
All
is
right,
what they call
Dee.
that.
Yeah, let me transfer it over to Patrick here, and let me ask you, Patrick. We were going to talk about division of assets and such like that.
So perhaps what I could do is I could give my best reply to this concern,
Sure.
and she could hear it off air rather than keep it going. But that's up to you.
Yeah, Dee, that I think what would be good is I'm going to have Patrick address the division of assets and what happens, are included in the assets before the division, and what to do after if something shows up that was not included in the affidavits and in the equitable distribution. So, Dee, I think that's a very helpful question, and I'm sure Patrick can address that for you. So, thank you for calling, Patrick.
Thank you.
So yes, thank you, Dee. So our system is set up, the family law system, with something called mandatory disclosure. So it's not even optional. There are certain financial disclosures that are required to take place, including financial affidavits, tax returns, credit card statements, checking account statements, deeds to property, and other documents. So each party has an obligation to disclose those things. In addition to which, there are discovery tools. If any of this is sort of thought to be something that needs to be done based on this man's activities, her former husband, you can take depositions as a discovery tool. You can send out interrogatories. You can check the public records. So the whole system is set up for transparency. And if people act in a transparent manner, they tend to have the best result.
Right.
And in my experience, those folks that think they can get over on either the other party or the court are in for a big problem, because if it can be established that someone intentionally did not disclose something or told about something that was not true, that entire divorce decree is subject to be set aside. So,
and a whole different equitable distribution can occur.
She referenced a couple of different things. For example, one of the things that we do in a divorce is we do an equitable distribution of marital assets and liabilities. Now, a marital asset is defined as something that is obtained from the date of marriage to the date the divorce is filed.
Divorce is filed or separation?
No, separation does not have legal significance. It's the date of divorce being filed. So actually, in these situations, if this man, her former husband, obtains something after the date the divorce was filed, that's not considered, at least on its face, marital property. That's non-marital, which you typically don't have to share with your spouse. The deeper and more interesting question is, what funds were used to buy this property? If it can be established through the discovery process, because one of the things we get is checking account statements, we get pay statements, so we can trace where money has gone. And there could be an entirely relatively innocent solution or explanation for this, that being, if the girlfriend bought the house, well, that's nothing that Dee, could complain about. Right. Or if a family member bought the house. So we don't know those facts. She believes that there's intrinsic fraud. There may be, but we want to be careful that we just don't jump to conclusions. When we take on this very serious thought process, this allegation that fraud, which is an intentional stated wrong, it's false, that you basically perpetrate a false statement to the court, which is equivalent to non-disclosure, it is a very serious allegation. If you can't prove it, you may be the person, like in Dee's situation. If she couldn't prove this fraud, she may have to pay for her former husband's lawyer to having gone through this. So that's the very first thing, is everyone should be transparent. They should review everything. The great reason for having an attorney, because a lot of attorneys are expensive. And I think a lot of folks who go through the process without an attorney don't realize the benefit an attorney could be to them. To utilize the discovery tools, to utilize an analysis and legal thinking and thinking like a lawyer and do the things lawyers do to try to uncover these things. Instead, they go through it on their own and they have bad results. So I frequently just tell people, you don't have to hire me, but you should get someone to help you through this. It makes a difference because there's a lot of people that I talk to after the divorce is filed, after it's over, that are not happy with the result. And it's over. Yeah. So if she is going to go to a lawyer and try to retain someone to file a motion to set aside her divorce decree based on intrinsic fraud, one of the very first things that lawyer is going to do is say, show me the proof that he used money you were entitled to buy this home.
I was going to ask you that. If he did, in fact, let's say they had a savings account when they were married, and he used money out of that savings account to buy that house, even if he put it in the girlfriend's name?
Well, that's a problem. Now, if the wife, the person in D's situation, got her half of the house, and he just used his half to buy the house, so what's the harm there? Okay. No. So you got to look at it, and you've got to analyze it, and you've got to try to look at it in context of the whole divorce. It's kind of hard just to say this guy is going to get this divorce set aside. Certainly, that's possible, and someone who intentionally commits fraud on the court is going to be in a difficult posture. They're going to have to pay not only their share of the money the other party was entitled to, but they're probably going to have to pay for their attorney's fees for that party.
Sure.
So it's not a good idea, right? As most cases of not telling the truth are not a good idea.
Most times you're going to get caught.
So that's what I would say to her. She should really have her proof, and then she's going to have to pay a lawyer. I mean, these lawyers don't, it's going to be expensive for her to have this thing set aside. So she should consider those things.
And we're talking about houses now. This isn't an D situation, but in other situations, I've heard, or the question's been asked is, I owned the house before I got married. But they lived in the house during the marriage.
It's a very interesting problem.
So is that a marital asset?
It's a very interesting problem. Let me try to explain it to you. We have a statute now that addresses this problem. And before there was a statute, there was a case in Florida called the Ka decision, K-A-A-A versus Ka.
Okay.
And what it addressed was this very concept of—
So you're not telling me that's Kaka.
All right. No, it's Ka versus Ka.
Oh, okay.
Close.
Sorry.
In any event, basically the issue properly presented is this. Can there be a marital portion to a non-marital asset? That is to say, the property was owned by one of the spouses prior to marriage. So by definition, that is a non-marital asset. However, during the marriage, say it's a longer term marriage where during that time, the mortgage was paid down, and as most properties do, it increased in value. The law is pretty clear that if you can establish that, then there is, in fact, a marital portion to a non-marital asset. And so if all the facts are there, it's certainly something we deal with on a fairly regular basis to determine what is that marital portion. And whatever that marital portion is, the spouse that was not on the property is entitled to 1/2 of the marital portion.
Oh, okay.
Similarly, with other things, there can be a marital portion. One of the things we deal with is pension. So we have police officers, firefighters. We also have people in more standard jobs. We have school teachers. They all Florida state retirement system. So your retirement in a divorce is considered, just like equity in a home, a marital asset. One of the key differences is retirement assets have not been taxed. They haven't been received yet. Typically, a person's not in pay status. So there is a way to find out, given the length of the marriage, you look at how much of that pension was earned prior to the marriage and how much was earned since the marriage. And there's a way to do what's called a coverture fraction to determine what the marital portion of that pension is. And then through the help of an expert, typically a lawyer that's trained to just do this kind of work, which is to prepare an order to divide or to allocate the marital portion between the parties, we can have an order signed by a judge. It's referred to as a qualified domestic relations order, or a quadro in short, to allocate to the non-working spouse that wasn't working to achieve the pension, a portion of the working spouse's pension. So we deal with marital assets and marital liabilities. So we are talking about assets, we're talking about property, we're talking about pensions, but there's also credit card debt.
Yeah, I was going to ask you about the
Yeah,
debt. We were
so-
talking about assets. So
Divorces happen for a number of reasons. Sometimes one of the factors is financial.
right.
People get themselves too deep in debt. Is nothing but arguments about that, and so we have to divide that up equally too.
I was going to ask you that. How do they divide up the debt?
Well,
I mean, is it who's
the law is pretty
responsible
clear.
for what?
The law is clear that there should presumptively be an equal division of the assets and debts. I tell you, one area that comes up a lot lately, in my practice anyway, have been these persons that go to school maybe in midlife and become, say, a nurse. These private nursing schools are expensive schools, right. And persons can have over $100,000 in student loan debt. Now, at the divorce, this is the crazy part of this law. At the divorce, the court must determine what is that student loan. And the current case law is clear that a student loan is a marital debt. Now, myself and other lawyers in this area say that makes no sense, because the only person that's going to benefit from that loan is the person who got the education. Yet it's considered a marital debt. And even that student loan, which nowadays a lot of times is not even being paid on because there have been so many deferments,
right?
That also gets allocated. But since there are also ways where someone who's burdened with a student loan can get that student loan relieved by doing certain things, like if you teach in a certain school for a certain period of time, do some kind of public service kind of work, they can actually forgive the student loan. A lot of times in agreements, we'll have a provision that the person who did not incur the student loan only pays when the person who pays their half, when the person who actually has to pay or is obligated pays their half. So it's like, it's usually on a monthly basis. So, yeah.
Wow. So that's student loans. That's one of the questions that I had about student loans. What about credit card? What if one spouse charged up the whole credit card and then they file for divorce, and who's responsible for that credit card?
It happens. So it happens a lot of times where, say, one of the parties, one of the married partners, is not creditworthy. They can't get a credit card,
right,
or they have difficulty. And so what happens in that case, the credit all goes on one person's name. Now, between the creditor and the parties, the creditor can only go after the person who actually signed up for the credit card.
Right.
But under marital and family law, the debt should be split between them. So you will have a judge, or you can even have an agreement, say that the party that didn't run up the card will pay for their share of it, half of it. Well, let's say that happens. The judge orders that, or they agree to that. It's approved by a judge, and any agreement that's approved by a judge with those kind of provisions carries the force of a court order. And the recalcitrant spouse, the spouse that didn't run up the debt, but is obligated, does not pay his or her half. Right. What do you do?
I know. Chase comes knocking on the door saying, "I want my payment."
Well, there's an interesting dichotomy in the law in this respect. And it's a distinction between what is a support obligation and what is a non-support or financial obligation. I'll give you an example. So a alimony or a child support obligation can be enforced in a much more serious way than a financial obligation. So if a person does not pay their child support, and what the other spouse, former spouse or partner can do is bring what's called a motion for contempt, especially if there's been a prior order requiring the child support. Because when you don't follow a court order, it's a pretty serious matter.
Sure.
You bring it before the judge. You say, "Judge, this is the order. It was entered. This person didn't follow it." There's a whole series of questions you ask pursuant to a case called Bowen versus Bowen, where the burden is really initially, once you establish that there's a court order, the burden shifts to the person who didn't pay to give an explanation why they didn't pay. Now, sometimes there's a good reason. They may have an accident, they lost their job. So it's only in the most serious of those situations where a person can actually, for example, the harshest penalty would be put in jail, but that would only be in the most serious situations. But my point here, the larger point, is that that's a serious way to address someone not keeping their payments. That kind of serious enforcement tool is not available to someone who doesn't pay a credit card debt, because the court does not see child support and credit card debt on the same level. Support obligations have a much more serious aspect to them. They can be enforced in a much more serious way. So basically, going back to our hypothetical where someone doesn't pay the credit card debt that they were obligated to under a judgment, what it leaves the other party to do is get a judgment against them. You get a piece of paper that says you owe me money because you didn't follow the court order. And as you know, pieces of paper aren't necessarily the most effective things to have, because if you, in Florida being a relatively difficult place to collect money from, things like your home, it cannot be taken from you. Joint property can't be taken from you. So you're left with limited availability to enforce that order.
Right. And so I was just thinking, how does Chase even have the creditor? I'm going to use Chase as the example. How do they have the standing to bring a claim against the non-charging?
They don't.
So they can't really even get a judgment against
not
the
against the
person
other one.
who didn't sign on the credit card.
They can only go against the spouse that has signed up for that credit card.
Right.
So thereafter, they'll get a judgment, for example, against that person, and then that party can bring in the other party, the other former spouse. They're saying, hey, listen, you were ordered, you have to pay, and I'm going after you for what I've had to pay of your share of my debt.
It's crazy. It's
crazy.
It family law can just expand in so many different ways.
But, we try to find ways to solve problems, too. So, like, for example, if we had that problem in a case, and if there was a marital home, nowadays, it's very hard to do anything other than to sell a marital home in a divorce because the interest rates have increased. So you have a house, you have a house that's encumbered by a mortgage, and maybe nowadays people have mortgages that are at 3%, some really reasonable, historically low interest rate, but now they've increased. Now they're 6 or 7%. So a person who has a certain payment, now they go through a divorce and they're looking, well, I want to buy out the other party's equity so I can have the house, and they look at what it's going to cost them. And it's just so expensive that they can't do it in most cases. So we're seeing, at least what I see a lot, is that parties are selling their marital home. And from the proceeds of sale, this is one way to try to be a problem solver, cause all the marital debt to be paid first before you divide the proceeds. That way the party that actually incurred the debt has a way of knowing that the other party is going to share in that debt.
And is that something that both sides have to agree to, or is that something that the judge can order?
The judge could order it. But again, my whole philosophy is there's very few situations where you're better off in front of a judge than you would be to solve it yourself.
Sure.
If you're able to do it, if you're able to separate the emotions and say, look, how many ways is there to solve this problem? You want to go have a stranger tell you how to do it, or you can figure it out yourself with the help of a lawyer. And that's what I advocate for them. Yeah.
And one of the ways to do that, and it's the same thing in our cases as well, is through mediation.
Yep.
Does family court require mediation in all cases?
Yeah, I actually serve as a mediator as well as an advocate. And so I can tell you that every case that's filed that doesn't settle after discovery has been exchanged is going to be required to go to mediation. And an interesting aspect of mediation is that since the pandemic, when we were so encumbered by the health aspects of being in the same place, mediations are almost always done through the medium of Zoom.
Right.
So that's a little different. So you lose a little of that immediacy that you had when you were in the same office. Like there would be lawyers with their clients coming to my office, or I would go to a lawyer's office that was a mediator, and you'd be right in their presence. They'd leave your room. They'd have a room for you, and they'd have a room for the other party and their lawyer, and you'd actually see the mediator go between two physical rooms. Now with Zoom, what we have are breakout rooms, as I'm sure you do this in your practice as well.
Yes, I'm old school. I like it, everybody getting in the same place together. But
I could tell you, maybe I've seen that once in the last few years.
I don't
it's so
see it.
rare, and you have to ask for it, and certain mediators will do it. I tell you, a lot of mediators, have either sold or stopped working out of their office space and work out of their home now, because most of what they're doing is Zoom. So it's not even possible unless that mediator comes to one of the lawyer's offices.
Right. But now mediation is effective. It can be effective if you have the right mediator, right?
It's not just the mediator. Yes, you need to have the right mediator, but you also have to prepare for mediation. In other words, you just don't show up, although that's all you're legally required to do is show up. I look at mediation as one of the most important parts of the case, because I know if that case doesn't settle at mediation, and of course there's instances where you do more than one mediation, but if it doesn't settle at mediation, now these parties are going to have to come up with significant trial retainers to pay their lawyers to have this tried in front of a judge. So, to review the discovery, to perform what we call an equitable distribution balance sheet, where we actually spread out the assets and debts and we come up with what one party would owe the other through an Excel spreadsheet. We analyze, if it's an alimony case, what alimony would be under the statute. So now we have a statute that tells us how alimony should presumptively be calculated. We have all of that done, and we met with the client. We've gone over it all. We've set their expectations. Of course, there's no guarantees, but you show up as prepared as you can, and you try to settle real hard. Now, not everyone gives that level of preparation to mediation. It has
to be the same on the other side as well.
If they're prepared, if they're good at what they do, they should be. And that's when you can settle cases. Right. When someone shows up, they're not prepared, they don't know what they don't know what to expect, they haven't looked at the case or analyzed their own position. Those are cases where we don't get settlements.
Right. And I see that in our cases as well, especially in our auto cases. Is, I enjoy the mediation. I always tell my clients, this is, as you were saying, one of the most important things is because you get to see a preview of the trial. What are they going to be bringing up? What are they not going to be bringing up?
Exactly. And sometimes, since I bill by the hour, sometimes, and this is something that's different lawyers approach it differently, but for people that are middle income, middle class, they're not gazillionaires, I try to hold on to taking depositions, which is a sworn statement under oath with a court reporter, until after mediation if I can. Sometimes I have to take it before just to find things out. But because mediation has another aspect, which is discovery. You can find things out. You can let the attorney on the other side know, hey, listen, I didn't get these documents. I have these questions about what did your client do with this money? Like this lady Dee talked about, let's talk about what's the deal with this house? Where'd that money come from? Where are the documents? And you can maybe clear some of that up in a way that's very time effective.
Right. And sometimes my clients complain that the other side, the insurance company on our side, wasn't prepared for mediation. And my philosophy is, oh, well, we're going to show them that we are, and we're going to show them that we're ready to take it all the way to a jury trial if you need to.
Well, it's also an example of a principle, which is you can only control the things that you have within your ability to control. And this is what I talk to my clients a lot about when they start getting, it's easy to get anxious, to suffer from anxiety. You're going through something so different and it means so much to your life. And I say, look, in all aspects of life, the only thing you can do is control the things you've got available to control. And the truth of the matter is we cannot control the things always that happen to us. In other words, things from outside of our control occur. Things that could happen in a married couple, like a partner has an affair. You can't control that. But what you can control is how you react to it.
Sure.
And that's what I try to say is let's try to react to this in a way that's a reasoned, calculated way. But I've seen, this is where lawyers can either do a great job or not so good a job for their client, because you have this person, this vulnerable human being that's subject to impression. And if you say that son of a gun did that to you, we're going to get them. That's what they want to hear, maybe. It's not what they really should hear, and it's not really what's good for them, but it's going to make the lawyer a lot of money.
Yeah.
And that's where people divide on the kind of, some people want to have a junkyard dog lawyer that's going to go after their spouse because they are angry at that person. And I understand that from a visceral human point of view. But over the course of time and the fullness of time, that doesn't make a lot of sense.
No, it can be quite costly.
Costly, not just financially.
Emotionally,
again,
too,
as
yes.
I referenced earlier in our discussion, you hold on to that
Sure.
Not only are you going to be dealing with that psychologically, it's going to affect your health.
It's fuel for that fire. I mean, if you're already angry and you have somebody feeding that anger and that resentment, it's harder to accept and to move forward.
That's where lawyers really serve the role of being a fiduciary, not just financially, but as the whole person. Is you have an obligation to help the whole person and not just sort of feed into their basest desires.
Right. When my legal assistant told my partner, she said, boy, in our Social Security disability practice, she said, boy, you do a lot of counseling to these clients. And Lori said the perfect thing. She goes, well, that's why we're called counselors of law, because we are counselors, not just of law, but also of life, of how what impact, whatever the situation may be. In our case, it's an injury. In your case, it's a relationship. We have to counsel them the best that we can based on our experience. And I think that's important.
Well, that's what I said earlier about the challenge and the sort of the great thing about what we do is we get to see people in the midst of their problems,
right?
Where they're the most vulnerable, and where an advice or a word said a certain way will have an effect that a word said another way would have a different effect on them and result in a different outcome. So the responsibility falls on us as lawyers, which is a great privilege to be, to do the best we can every day.
Yeah. Now, Patrick, we have a few more minutes. I have all these pages to talk. They have questions about that.
Talking a lot today.
But that's perfect. I love this. That means you have to come back again to talk about the changes in alimony, the recent changes in alimony. I guess
2 years ago, almost.
Yeah, it's still recent for us.
So I can talk about that real. Do you even have time? No.
Sure. Yeah.
I could. Couple minutes. So in 2023, a couple things happened in July of that year. One was there was a presumption now given in the law with regard to time sharing that there should be 50-50 equal time sharing as a presumption. It can be overcome, but this has been monumental. Fathers' rights groups for a long time have been trying to do that. And it does, in a way, set expectations so a way we can solve that problem. And of course, the family has changed where now moms are not like Leave It to Beaver moms. They're like working women all the time. So it makes some sense. But on alimony, we do this calculation where we look at the wife's need as portrayed in her financial affidavit, which shows her income coming in, her expenses coming out. And we look at that number, that deficit number, and we compare that to the mathematical calculation of the difference between the husband's net income and the wife's net income multiplied by 35%. Whichever is lower, the need or 35% of the differences in their incomes, that's the presumptive amount of alimony. Now, that can be helpful. It doesn't solve every case because nobody wants to pay alimony. So you wind up yourself many times in front of the court. If you're going to be in front of the judge, it's because of alimony, in my experience anyway, or it's because of child-related issues.
Yeah, I can imagine. And there's a lot of math. Yeah, I tell my son, I said, you got to love math because it impacts all kinds of things. Yeah. No, and there's no more permanent alimony. Is that correct?
Permanent alimony was done away with at the same time. It's now called durational. Yeah. And depending on the length of the marriage, there's some presumptive maximum amounts of time, amounts of alimony. But all of that, or a length of alimony, the duration is often a subject of negotiation.
Yeah, Patrick, appreciate you. We're almost out of time, but I want to make sure that our listeners get your information of how they can contact you, because we didn't cover even just a little bit about family law.
Well, I'm right around the corner from you, man.
I know. So why don't you tell our listeners how they can get in touch with you?
It's Peacock, Gaffney, and Damanakis, and you can just Google me and you'll find it.
And the telephone number?
727-796-7774.
That's perfect. That wraps up another edition of FLALAW on the radio. I am Matthew Noyes. I'll see you next week. In the meantime, drive safely and watch out for those who don't. Take care.